Welcome to another episode of Immigration and Mobility Decoded. I am one of your hosts, Cecily Petrie, joined as always by Eric Prado. Eric, how are you?
I'm doing good, Cecily. How are you doing?
I am well. We're into June here, and Chicago is finally turning a corner on the weather, and I couldn't be happier.
Likewise. We are recording this in the first few days of June, and outside the weather is pretty nice. Although there's some haziness in the air. I think there's some wildfires in rural parts of Canada. I think all that smoke or whatever's coming down, so the air quality is not the best. But you know what? It's getting warmer.
Yes, I know that happened. Was it last summer or the summer before where it was so bad from Canada and you could like barely walk outside?
I think it was 2 summers ago where there for like a week, the weather, the air quality was pretty bad. Yeah.
I hope everything is getting contained there, but we are enjoying a little bit of nicer weather. And we have a really great episode today with Ryan Harris, a partner at Corporate Immigration Partners, Envoy Global's affiliated law firm. And Eric would love to hear your thoughts on Ryan's episode, kind of give a little prelude to the listeners.
Yeah, I found the conversation very engaging and insightful. I think with the backdrop of a lot of things happening, in the first 6 months of the year, but then obviously since the second Trump administration took office, there have been a lot of policy updates, litigation updates, and chatter and other actions that are impacting business immigration and just that everything really. And so Ryan hopped on the show to provide some updates. It is a good way to kind of this mid-year update type of feel to it, so it is nice to hear it from that viewpoint, but also just kind of like a recap. There have been a lot of things coming out from the government that it's easy to miss some updates. So I think Ryan, he did a really great job, and it was really interesting to hear his thoughts about some recent updates and things that are top of mind for him, but also top of mind with some of the employers and human resources professionals that he is speaking with daily, and just kind of providing guidance during times where a lot is changing. And as from the employer perspective, the best way, how can they best be proactive and plan ahead in light of the uncertainty with in quite a few areas. But Cecily, I'm curious to hear your thoughts as well.
Yeah, I would agree with you. I think it was a really great conversation, and Ryan provided a lot of great insights. I think the success of the H-1B lottery was one piece that we covered, and I think that's obviously very topical, almost giving us a sort of recap of what they saw from a numbers perspective in the lottery and what the success rate looked like. And as you mentioned, student visas, breaking news in immigration and litigation. I think overall it was a really great episode to jumpstart what we've seen in terms of immigration in the last 6 months, and with a new administration, and maybe looking to what we may be expecting to come later this year. And now here's our episode with Ryan Harris, partner, Corporate Immigration Partners.
Hello, and welcome to another episode of Immigration and Mobility Decoded. I'm one of your hosts, Eric Prado, and I'm joined by my co-host, Cecily Petrie. And we're excited to welcome Ryan Harris, a partner at Corporate Immigration Partners, to the show today. We have a lot to discuss. There's a lot happening, but Ryan, really quickly, I think you are third. You're on here for the third time, so props to you for that. But just want to see how things going, and I know it's been a busy time, but how are you doing?
I'm doing well. Thanks for having me back on. You're right. There's a lot happening in U.S. immigration right now, so we're doing our best to keep up with the pace of change.
Yeah. And Ryan, maybe for some new first time listeners, etc., can you quickly dive into your background in immigration law and just kind of where you are in your career at the moment?
Sure. I started my immigration law career way back in 2006 as a paralegal, actually, and have just sort of climbed up the rungs of the immigration law firm world up to where I am now as a partner at CIP. So coming up on 20 years of time in that space. During that time, have had the opportunity to see several administrations come and go, and one come back as the era that we're in now. Um, you know, Having that perspective, we've seen many of the same problems in immigration that have, in the skilled immigration space have persisted or even gotten worse in some cases during that time, right? The cost for employers going up, the timelines really being longer than anybody wants them to be, and that really not changing over time or in fact getting worse. We've seen some micro improvements along the way, that are really meaningful for folks, such as work permits for spouses of H-1B workers, right, during the Obama administration. We've seen USCIS expand the availability of premium processing. We've seen the development of online H-1B cap registration, which we're going to talk a little bit more about today. So some tinkering around the edges that have, created more benefits for people, made the systems in some way work somewhat better. But in that 20 years, I'm remembering having a senior attorney at the firm where I was a paralegal back in 2006 really express optimism for the negotiations that were going on in Congress at that time to have really fundamental immigration reform. It, of course, went nowhere. There's really been no major legislative changes since then. So as much as the new administration is changing things, we really haven't seen real progress toward any kind of fundamental reform of the immigration system. And that just sort of communicates the fact that it's really hard to do, even for an administration like the present one that ran on immigration as a central issue in the campaign, that changing the architecture of the system is very hard work.
Yeah, I feel there's almost an entire hours or two multiple hours worth of episodes to go over the history of potential immigration legislation that has been discussed since like 2000. I think your timeline, 2006 to 2010, it was the Gang of Eight, and they were very, very close. I think that potential legislation was tanked by like a vote or two. It was very, very short. And even as recently as what was it, last year, I think there was a piece of legislation that was near the finish line that got tanked.
Yeah, and you've seen the players change as well. Senator Rubio, then Senator Rubio at the time, being part of that gang that was looking at doing fundamental sort of across the board improvements and enhancements to the system. Now as Secretary of State, being a real hardliner in the current administration in terms of the restrictionist attitudes kind of prevailing today.
We could save that conversation for offline about maybe why those viewpoints have changed, but it is definitely jarring to see views change over the years. But Ryan, that is a very timely episode. We are recording this on Monday, June 2nd. And, for us, it represents that halfway point of the year, just to kind of see where things are. And I think this particular episode takes on a little bit more importance because not only is it the halfway point, but as you alluded to a few seconds ago, it is this, we're still in the early months of a second Trump administration. And I don't think it's not crazy to say that, what we've seen there's been a lot more change than compared to the first one. And so I think with that, let's hop into it. I'm going to hand it off to Cecily to kind of run, start with H-1B, and then we have a list of topics and we'll go from there.
Yeah, absolutely. So we will start on H-1B cap season. So obviously we've completed the lottery for fiscal year 2026. From your perspective and some of the data that you've seen, Ryan, how did this H-1B cap season go and kind of perform as to past years?
Yeah, so from a technical standpoint, the online registration system continues to work pretty well. It's a much more efficient system than, for instance, back in my 2006 era when we were getting started. We packed up boxes and boxes of petitions that, the trucks came and picked them up, and we had to file all those cases with immigration. And so now having this pre-screening where you can do it online before you have to file a full case is really a more efficient approach. There was a change 2 years ago to limit each capped registrant to just a single chance at selection. So everybody gets sort of one lottery ticket, even if you have multiple job offers. And that really seems to have been effective on both cutting down what appeared to be some fraudulent gaming of the system, right, where you had individual beneficiaries had tens of 40, 50, 60 registrations going in that really caused question as to whether or not those were real job offers behind each of those registration numbers. So now everybody gets their one shot, and that's increased the selection rate, which we love to see.
Yeah, and I think another thing people are kind of thinking about is if that increased the selection rate, what are we looking for in terms of, is there going to be a second H-1B cap lottery? I think in fiscal year 2025, we saw a second lottery in early August. Any prediction of what you're thinking, and could we see a second H-1B cap lottery?
It is always possible. We never know until we know, and the government, just sort of runs the new lottery, and we find out as it happens. And you've got the time frame right. It's usually July, August, where a second lottery occurs. There's even in some years been a third lottery if there's still, numbers at the bottom of the barrel that didn't get used. So we will have to see in the next couple months here what the results are in terms of the selections that have already been made, and USCIS will count up how many selections resulted in a petition being filed and approved, right? If some of those cases get denied, those numbers should go back into the hat to be selected for new registrants. So this could happen in the next couple months. It's usually pretty small numbers if there's a subsequent lottery from the first lottery, because there's just, so statistically speaking, your chances are not great, but there's kind of always still hope until they close the door and make the announcement in the fall that the lottery has closed for the year.
Okay, great. Yeah. So there's still hope for some people with that lottery, even the smaller number. So we'll definitely keep an eye out for that as we round out the summer.
Something else we saw this year was somewhat of a drop in registration numbers. Hard to say, exactly what causes that. There will be some postmortem analyses, I'm sure. A few things that could be at play here. The registration fee increased from just a minor $10 to put a name into the ring to $215 this year. So employers have a little more skin in the game in deciding who they're going to sponsor in registration. If you've got a big program, right, those fees can add up. Macroeconomic conditions, what we're seeing in tech with some layoffs and some sort of limited growth, could be resulting in less hiring. And I think, just generic concerns about immigration cost enforcement could be leading to, some employers' less willingness to use H-1B as a core part of their talent strategy. So that story will continue to develop, but what it means when you have less registrants is the people that are in the lottery have a better chance of getting selected. So good news there.
Yeah. And for those registration fee increases, I think we also saw a filing fee increase maybe last year. Is that something that you think will stay steady for the foreseeable future, or do you think we'll see a continued increase in some of those registration fees and filing fees in general?
Yeah, the registration fee, it was $10 for 4 years, I think. And so significant increase there. There's nothing on the table right now being proposed in terms of filing fees increases. But, the trend at USCIS over the long history is filing fees really only move in one direction, and that's up. So the last filing fee increase that was very significant, adding, support, cost support for the asylum system as part of the H-1B case, which was fairly controversial. And just the raising of fees across the board. What we haven't seen that result in, disappointingly, is improved processing times, right? So increased fees, you'd expect the service to go up, and that tends really not to happen at USCIS if you look at the history of fee increases. So, we'll hope that there's not another one right around the corner. There's some discussion in the big, beautiful bill debate that's happening right now that there could be some immigration fee increases, especially for the asylum system involved in that legislation. So something we're always on the lookout for, perhaps not this year.
Understood. That's helpful. And I think overall, we definitely saw an increase in that selection. So for people going through the lottery process, that was kind of the overarching positive theme there. As we kind of round out the H-1B cap discussion, there's nothing for you to add. I think Eric will kind of jump in and we'll touch on student visas.
Yeah. Thank you, Cecily. Ryan, student visas, there's a lot going on, and I feel like it ties into a broader theme. Or when we started the conversation, you alluded to, there's just a history of failed immigration legislation, and particularly here in the U.S., it's very hard, as you know, to, change the U.S. immigration system in a substantial way. But there are those unique aspects that all administrations use, to set rules or policy decisions at either a department level or at the agency level, USCIS, etc. Um, Before we touch on the student visas, is there anything new in immigration rules that visa holders should be aware of? Things that maybe have, I don't want to say flown under the radar, but in the in the avalanche of news, maybe don't grab the headlines.
Yeah, one big one is the alien registration requirement. This is not a new law. It's rather an authority that the current administration kind of dusted off from World War II era, basically. There being a requirement on the books that aliens, meaning non-citizens in the U.S., register with the government. Up until April, there really was no mechanism in modern history to even do the registration. And so it was just a rule that was sort of on the books but not enforced. The Trump administration has now sort of revived that. They've created an online registration system that does require all non-citizens to register. In the skilled immigration space, there's not a ton of impact on this because if you have been stamped for a visa and you've processed through a consulate and you've entered the US on that visa and received an I-94 entry record, that is your registration. So you don't need to actually do anything. You don't need to follow the new special procedure that is really more targeted at the undocumented population. The exception to that is if you have a child that you've brought over with you on a visa, when that child turns 14 years old, you do have to, as the parent, register that child affirmatively. You have to follow the process. It's a pretty simple form you need to fill out online. But there is a requirement with criminal penalties that apply if you do not register that child within 30 days of their 14th birthday in the US. Once you perform the registration for a 14-year-old child, you should expect within the few weeks thereafter to get a biometrics appointment notice. And so you'll use that to take your teen into a local USCIS office, and they will collect fingerprints and photos, which they do not collect at the consulate level when you're applying for the visa for kids that are younger than 14. So that's why there's a dividing line there. So parents just need to be aware of that requirement as we move forward in time.
Got it. So shifting to student visas again, this episode does have a timely matter to it. We are recording again June 2nd. And so last week, that final week of May, post Memorial Day, Ryan, there was quite a bit of news regarding student visas. The first big news item that dropped was it was reported that the State Department paused new F-1 visa interviews. We started to see some early reports from Politico and Axios early last week, and then they got a hold of a cable from Secretary of State Marco Rubio to embassies and consulates. What is the latest on this particular development?
That's about as much as we know for now. So F-1 visa processing, the setting of new appointments has apparently been paused at U.S. consulates around the world. I believe that if you already had an appointment booked, that those appointments are expected to go forward. But it's unclear when the interviews are going to resume. What the administration has said is that they intend to continue the F-1 interview scheduling once they have developed a process for doing additional security vetting. And what that means is it's clear that there's going to be more of a deep probe into the social media presence of applicants for these F-1 student visas. So what are they looking for? Not a ton of clarity from the administration on sort of what could be an issue for visa processing. We know that they've been very focused on the Israel-Palestine issue, and expressions of support for the pro-Palestinian viewpoint has been issue in a number of cases that are being litigated in U.S. courts right now, raising some First Amendment concerns about how much free speech does a temporary visitor on a visa have in the U.S. So really anyone who's in the U.S. or planning on being in the U.S. on a temporary visa, whether it's a student visa or otherwise, should just for now be aware that some political viewpoints expressed through social media can impact the benefits applications for your visas, for work permits, for visa extensions, and in some cases, the ability to maintain status in the U.S. We'd all love as practitioners to get more clarity from the administration in terms of what we can warn people about, sort of what are the things that could be a problem for visa issuance. And really, we'll probably have to see that play out in the individual cases to get more clarity.
You've mentioned a few times that things have come out, but there hasn't been a lot of clarity. And so I'm wondering, from your professional viewpoint, how do you navigate these types of situations? Like when you see news reports coming out, are are you just walk me through like what you're going through?
Yeah, it makes it tough, really, for us to give the best advice because the sort of recurring theme here, and we're seeing this again in statements from Secretary Rubio, that there's going to be a targeting and a focus on revocations of specifically Chinese nationals' visas, student visas, for folks who may be in concerning fields. Um, Again, unclear what those exact precise fields are. If there are undefined ties to the Chinese Communist Party, that those could be issues where the department would go in and affirmatively revoke a visa. And so, without the specifics on what it is that they're looking for and what are the criteria that are being used, which haven't been released yet, um, it makes it impossible in some cases to answer the question, am I at risk? And so what you're seeing, and a lot of professionals do, are pretty conservative travel advice right now, um, given that it is very difficult to challenge a decision that's made outside of the US at a consulate about whether the visa is issued. There's a lot of case law on whether you can even get a court involved if you feel like the consulate got it wrong or denied a visa when they should have approved it. And so, if there's sort of any question that you might be falling within some of these areas of focus that the administration is being restrictive on, you want to make sure you're talking to a experienced attorney and making a real decision about the risk calculus of, should I be making this trip right now or not.
You mentioned the revocation of visas for Chinese students. That was news that broke on Friday. Any other details that have come out since then?
Nothing yet, and everybody is watching very closely to see what will occur with that area of focus. Um, what we did just see in recent weeks were viewpoint based, either social media expressions or even minor criminal issues like speeding tickets, sort of interactions with police that didn't even lead to charges in the F-1 student visa space, leading to revocations of visa and termination of status within the U.S. in what's called the CVIS system. And this is the registration system that schools use to keep track of foreign students. Um, there are a bunch of court challenges that occurred following that. The administration seems to have kind of backed off for now and is pausing the revocation of those visas, but has made statements in the litigation that's ongoing that they're developing likely a process. And so it's, this issue is not over, I think, by any stretch. But what we may get from the administration is, better than nothing, is having at least some specific criteria listed in an actual process laid out that we can look at when these problems arise.
What are your high level thoughts, if you will, on these recent actions? They definitely seem to be geared toward the higher education system. You mentioned CVIS. There's a few weeks ago there was, I believe, an attempt, or I believe there's discussions. The administration wants to specifically, tell Harvard who it can and can't enroll, particularly when it comes to international students. I feel like we didn't see this in the first administration, particularly with targeting toward higher education. Do you have any initial insights, or what would the reasoning be, in your opinion?
Yeah, I mean, past has not really yet been exact prologue with Trump 1.0 versus Trump 2.0. There are some issues, for instance, in H-1B adjudications that received a big spike in challenges, what we call requests for evidence, and even denials of those petitions. It hasn't really revived yet in the H-1B system. And while that, it being a positive thing as a practitioner in this space, right, that we have fairly predictable adjudications of these H-1B petitions for now, we have this new focus, as you're pointing out, in the F-1 space. This is important for U.S. employers because the F-1 students who come out with work permits called OPT are often a talent pipeline, right, for interns and junior engineers that come in and then ultimately transition to a visa like an H-1B if they can make it through the lottery. And sort of latest news on that, we don't have a USCIS director right now. There's an acting director in charge. the nominee for USCS Director, Joseph Edlow, was in recent congressional hearings on his nomination, suggested that the administration could actually end or at least restrict OPT, meaning, you may not even have work authorization that flows from the grant of a degree at a U.S. university. So big impacts to the talent pipeline. The administration, does not seem to be backing off of this as a focus area in terms of limiting the visas, limiting what schools can even hold or educate foreign students, and then what kind of work permission is available for these students after. So it's all very much up in the air right now.
Definitely a lot to monitor, and something we'll keep our eyes on very closely, because I feel when it comes to education, there are those immediate impacts. The foreign students coming into the country, and you mentioned the talent pipelines, and there's even more downstream effects. I've seen some articles about if you reduce international student enrollment, that could potentially impact in-state tuition or tuition in general for U.S. students. You have the economic impacts on those college towns if enrollment declines, and so there's a lot of things that are we'll keep our eyes on, and we'll report back. Again, since January 20th, there has been a lot going on, particularly in the world of, we'll call it, litigation. So I'm going to turn it back to Cecily for you guys to kind of discuss what's going on that front.
And I know that discussion on F-1 students was a bit gloomy, so let me just maybe close that out with some practical advice for folks that are out there, intending to come to the U.S. on a student visa or needing to travel or renew on a student visa. Number one, be aware that your social media presence can impact your U.S. status. So just, be thoughtful about what you're putting on social media, understanding that is very likely to be reviewed even after and be monitored even after a visa appointment goes off. If you're dealing with any kind of minor infraction issue, a traffic issue, my suggestion is, work with an attorney to negotiate the charges to be minimized to the extent possible, such that you don't have things like traffic tickets, popping up and being a problem for visa issuance. So getting things dismissed or reframed and using a defense attorney to do that is probably worthwhile right now. And talk to an immigration attorney before traveling abroad. Like I said, because of this doctrine of consular non-reviewability, very little can be done once you're outside the U.S. if you run into a problem with visa issuance, right? Consulates basically get all the discretion in the world to decide which way a visa goes. And if we're not sure what standards are even being applied, you need to take that risk into account.
Yeah, that's very helpful just for, some of those students or employers that are looking at like F-1 students in general. So great to have that idea and insight for people that are listening. I think from the perspective of litigation, since January, there has been a lot of litigation surrounding immigration matters. I think we've seen birthright citizenship called into question. On the more breaking news side, we've seen that the Supreme Court allows the administration to revoke temporary legal status for about 500,000 immigrants. So this is targeting a Biden-era humanitarian program that allowed immigrants from China, Haiti, Nicaragua, and Venezuela to live and work in the U.S. legally. So that's, from the breaking news side, something that we've seen. Ryan, if you could kind of give us a recap of and some potential implications of some of the most talked about immigration litigation situations we've seen since January, including some additional details on the aforementioned.
Yeah, a lot going on in that space as well, and a lot of kind of whiplash and, one lower court deciding a certain way, and then you have an appellate court or even the Supreme Court coming in and changing course. So a lot of sudden shifts that are happening right now. I think it's causing a fair amount of anxiety. The high profile cases that we've seen covered so far, sort of taking out the F-1 student cases that we just talked about, that seems to be sort of on hold for now while the administration comes up with a process for that. What we've seen otherwise are really areas of due process for deportation rules, and issues like the humanitarian statuses, like for refugees and asylees, temporary protected status, and this humanitarian parole program. A lot of changes afoot there. Maybe starting with birthright citizenship, that being one that really does have a major impact on the skilled immigration population that might be more of our audience today. It's a very big question to be decided that the Supreme Court is ultimately going to have to weigh in on. The president's executive order, that was one of these day one orders that happened just after inauguration, basically set forth a policy that if mom or dad is not either a U.S. citizen or a green card holder, so if you have two parents on H-1B or a parent on H-1B and a spouse on an H-4 visa, that a child born in the U.S., physically born in the U.S., would no longer be a citizen unless either mom or dad is a U.S. citizen or a green card holder. That would obviously be a radical change with enormous consequences for a lot of people. There's a lot of unanswered questions that remain of, okay, if that were the rule, what would the status of that child be? Unclear. So the Supreme Court recently heard arguments on the executive order. I think there may be a misunderstanding in the public that they're weighing the question of whether or not they're going to allow the president's view on birthright citizenship to prevail. We may not get a final answer on that in the near term. The case that the Supreme Court just heard was through the emergency docket, or sometimes called the shadow docket. It was a more narrow review of the ability of lower federal courts to issue nationwide injunctions. And an injunction is just a legal term where a litigant, for instance, who feels harmed by the president's order can go in and ask the court for an order that the executive order on birthright citizenship is illegal and shouldn't be applied, right? That's an injunction that the court could issue. Several injunctions have been issued as to the birthright citizenship order. There have been a number of other lower court injunctions based on other administration policies, both immigration and not. And what the Supreme Court seems to be looking at specifically in the way that this case has come up on the emergency docket is can lower courts issue nationwide rulings that affect the whole country, or should their rulings be limited to the state or the district that they're in? The big concern from immigration lawyers like me is that could make a quite confusing patchwork of rules across the country that would depend on how courts are ruling and how far those rulings go, such that, and this was brought up in the oral arguments that happened on the birthright citizenship case, of you could have a baby born in one state being a citizen and a baby born in the neighboring state born and not a citizen. And what happens when those children cross state lines, right? Does a child born in a non-citizen state become a citizen when they cross the state line into a state where the executive order is not enforced? Again, very unclear how that would work and how that would be administered. So a lot of questions to be answered on that, and it may even be several more years before we get a final answer from the Supreme Court as to whether or not birthright citizenship is guaranteed. Again, sort of practical advice for this while we're waiting on the courts to give us clarity. If you are on a visa in the U.S. and you have a baby here who is, for now, under the current rules, a U.S. citizen, I'd say apply for that U.S. passport as soon as you can right now, in case the rules change, even region to region, state to state.
Ryan, if I can just hop in real quick, I just think just hearing you the last few minutes, it's such a fascinating topic of discussion. The Supreme Court looking at the nationwide injunctions and whether they want to rein that in. I feel like the crux of that almost gets back to the founding of the United States, right? With federal system versus the state system, and particularly when it comes to immigration, you have these downstream effects, right? It's just a fascinating thing to think about that almost 200 years. Sorry if I'm getting the birth of the age of the country a little bit wrong there, but we're still having this discussion.
Yeah, and we're sort of living through history on this as it changes, and so this idea of whether lower courts can issue nationwide injunctions, it goes far beyond birthright citizenship. It even goes far beyond immigration, right? Of having rules that apply differently based on what state soil you stand on, I think is something that would be surprising to most people. But it's where we could be headed if the Supreme Court really limits the ability of these lower courts to issue nationwide injunctions. And the birthright citizenship case, basically the reason given was that the order seemed to the judges who've all looked at it so far so patently unconstitutional and against what the 14th Amendment pretty plainly says about every U.S. citizen, or every person born in the U.S. being a U.S. citizen, that it necessitated a nationwide order. And so the Supreme Court, that's what they're going to weigh in on soon, is whether or not that's a legitimate way to handle those cases.
And I think too, it also shows that the lack of action on immigration from the legislative process is really coming back to bite everyone, really. There's been no meaningful legislation, and so now all these things are coming to a head, and it's maddening.
That's right, and it really leaves immigration to the province of the executive and whoever that executive happens to be, right, based on the last election. And you have this sort of whipsaw effect where President Biden can invite 500,000 people to come in through these humanitarian parole program, and then because of an election happens, and a snap of a finger, you can have that status revoked, and so it makes the system, less reliable, less predictable, more volatile, which I think probably no one wants. With the revocation of the humanitarian parole, we've kind of seen this pop up in a few different cases. The administration moved toward revoking as well temporary protected status, which is a country-specific status based on crises that are happening in someone's home country. So we have that for Ukraine and for Venezuela and a number of other countries, Afghanistan, that the administration has talked about rescinding or limiting that or not renewing the TPS. A lower court came in and slowed the administration down in terms of revocation for TPS, much like in the humanitarian parole scenario. And the Supreme Court in both of those instances came in and really sort of gave license to the administration to decide and have the discretion to decide whether or not we're going to continue these sort of protective statuses. And so that's the trend, and that's the theme. We saw this come up in the first Trump administration over the battles over the so-called Muslim ban, which is the travel ban on visa issuance for nationals of a number of predominantly Muslim nations, where lower courts said, wait a minute, we don't think this flies under constitutional rules, and the Supreme Court coming in and saying, actually, yes, the administration, the president gets a lot of executive authority to decide who gets to come in and when and for what reasons. And so that theme is continuing in Trump 2.0, that the Supreme Court is being fairly deferential to the administration on some of these issues. That doesn't mean they will be on every issue. An exception to that, even in the Trump 1.0, is the DACA or dreamer status, deferred arrival, came up where the Supreme Court reviewed the Trump administration's actions to terminate that program and ruled against the Trump first administration on that and said no, that they actually didn't follow the correct procedures to eliminate that. And DACA still exists today because of that ruling. But we're seeing on a lot of these humanitarian areas that the administration seems to be very focused on with respect to TPS, humanitarian parole, refugees and asylees, that the Supreme Court is going to give the president a lot of leeway to decide what happens there.
We heard your kind of opinion. If you're looking between Trump's first administration and Trump's second administration, it's obviously still early in the second, but are there any additional kind of historical examples that we can learn from about what happens next?
Trump 1.0 to Trump 2.0, like I said, we're faring, I think, better in the H-1B or sort of working visa space. That won't necessarily continue, right? We still could run into changes as, for instance, a appointed USCIS director takes over. There could be, rule changes or policy changes. It could be quite sudden that could apply in that space. But so far, they seem to be really focused in the early days on more of the deportation regime, on limiting these humanitarian statuses, and have not been as focused on the skilled immigration space. We'll see. To a bigger picture, the history of immigration in the U.S. tends to cycle back and forth. If you look over the sort of broad arc of history toward, from restrictionist or kind of nativist attitudes about limiting the amount of people that come in, limiting the benefits that are available, to going back to more openness to immigration and appreciation of the benefits of a multicultural, or the melting pot society. And we're on that pendulum right now, and it's swinging right now towards the more restrictionist view. History would tell us that will hit its zenith and we'll start going back the other way. Sort of when that happens, harder to say.
History repeats itself. Yep. I think it would be great if we could kind of end this kind of piece on the litigation of some words of wisdom that you'd be able to provide to our listeners.
Sure. Writing out this era, and that's kind of what we're doing in my view, is just kind of riding it through like we did with Trump 1.0. And I've said to people who are concerned about going through another Trump administration and the impacts that that could have and the hardships that that can impose on immigrants and immigration benefits is, we as the legal bar have been, on the field with this team before. We got through it one time. We'll get through it again. But it's really important as ever now to make sure you've got experts you can rely on who can strategically assess, how these shifts are impacting your program, if you have a foreign national employee program, and what steps you can take to mitigate the risks based on, where we see the administration going next.
I think that's very helpful, and agreeing on the strategically assessing everything that's going on and staying up to date on the news that seems to be coming every time we close our eyes. We blink, there's something new.
Right.
But appreciate all of your insight.
And something that doesn't change is, the need for foreign talent and foreign entrepreneurship and ingenuity is not going to go away, right? That's always been a part of the dynamism of the U.S. economy. And so that need and that demand for skilled folks from around the world to come and contribute to the U.S. economy is, that's not going to change. And so that's a really strong undercurrent that we should think about, regardless of the momentary hardships we might face.
I think that's spot on, especially in this age of AI becoming more and more prominent, and tech companies, kind of rethinking their products and offerings and services. And there's just the AI boon is either upon us or coming soon. And a lot of those companies are US based, so they're going to need that talent, as you mentioned. So Ryan, we hit on quite a few major themes and topics. I'm wondering, as we look to kind of close things out, are there any, maybe we'll call them like quick hitters of, things that maybe we didn't touch on in depth, but you think that, listeners should know about or, consider? I know at the start you mentioned travel and whatnot, and there were a few either updates that came out, or particularly with the summer travel season coming up, things that people should just kind of be aware of, and things like that.
Yeah. I don't want to be overly alarmist, and most people who have, no status issues, have their documentation in order, haven't had any issues with the police, even for minor tickets and things like that, the squeaky clean record. Most people are not having problems traveling, getting their visa, right? There's a lot of the system that is being administered as usual. But there's just some level of unknowable, increased risk because of the attitudes of extreme vetting, because the administration seems to be adding things to the list of what they're going to look at in visa interviews, that if you have concerns, just make sure you're talking to a lawyer. If you're working with an immigration lawyer, please be patient with us. We are doing our best to keep up with the pace of change and to make sure you're informed. And, we've shifted our advice to be more conservative than we were a year ago. Out of necessity. And so, just keep that in mind. I know life happens, right? Not everybody can't agree not to travel forever and be landlocked, because we have, family members that get sick. We have family members that have birthdays and weddings that we want to get to. So we completely understand the need to travel and need to move about the world, doesn't go on pause itself. But our advice is kind of consider what you really think to be essential right now. And until we have more clarity, which should arise over the next number of months, right, as we see more results, as we see the administration, take positions in these court cases that we're all watching, we'll have better advice for you. If our advice is we're not sure, take that to heart and decide, if you really need to make that trip. And if you're going to do so, what's my plan B? What's my plan C, even in case what I thought was going to be a short trip becomes a more prolonged trip because of delays at the consulate or things like that. So just keep all that in mind. There's only so much we can control.
Maybe shifting to the employer perspective, I think one of the hallmarks of Trump 1.0, now Trump 2.0, is it kind of forces us to be more reactive than proactive. We're reacting to the avalanche of news and things that come out. But Ryan, in your discussions with employers and maybe kind of thinking ahead, are there ways that employers could be more proactive as best as possible?
Sure. And I think some of that's taking cues from Trump 1.0, and in case some of those headwinds come back, right? We've got sort of our game plan for that we've been reviewing as practicing attorneys of, knowing what move, to make in reaction to some of the things we saw occur in the last Trump administration. So we're sort of ready for those, but expect things to take a bit longer, expect to have to fight maybe a little bit harder. Even in Trump 1.0, when we saw the real spike in requests for evidence, for instance, going from the norm of single-digit percentage to upwards of 25-30% of cases being challenged, end of the day, our team was able to still fight most of those cases to approval, but there was more anxiety involved. There was a little bit more expense involved for the employer to do the legal work to litigate those cases out to approval. But we were able to prevail there, and we expect the same here, right? We've got an area of law in terms of skilled immigration where we, in most cases, have the law and the facts on our side. And so that usually does lead to wins if we're prepared and if we know, what the immigration is or what the administration is focused on.
Well, Ryan, very informative discussion today. Appreciate you hopping on. The door is always open for you to come back on, so feel free to reach out to Cecily or myself, particularly as news breaks, or if we need to discuss anything in more detail. But as we look to wrap things up, any final thoughts or closing remarks on anything we discussed, or again, we are in early June, anything you're looking forward to or you have your eyes set on over these next few months?
Oh, we're excited to get the rest of these CAP cases filed. And, this is when it was an exciting time of year for business immigration, right, where we see people really, realizing dreams of launching from that student visa into their H-1B visa. And so, we'll continue to do as best we can with some of the challenges we're facing in terms of timelines. But, it's the old adage, failing to prepare is preparing to fail. So make sure you are taking a look at those policies and doing updates with your immigration practitioners to make sure you're sort of ready for the era that we're headed into.
No, but this was great. And Ryan, as echoing what Eric said, we really appreciate your time, especially in this busy season of business immigration. So thank you for your time. And we're looking forward to everyone's feedback on the episode.
Happy to be here. Thanks for having me on.